over the winter closure. So beginning with Professor Goldsmith, he is the learned hand professor of law at Harvard, and we're thrilled to have him visiting us for a couple of weeks right now. He's the author most recently of After Trump, Reconstructing the Presidency, and In Hoffa's Shadow, A Stepfather, A Disappearance in Detroit, and My Search for the Truth, as well as other books and articles on many topics related to presidential power, terrorism, national security, international law, and internet law. Before arriving at Harvard, he served as Assistant Attorney General, Office of Legal Counsel from October 2003 through July 2004, as well as Special Counsel to the General Counsel to the Department of Defense from September 2002 through June 2003. He clerked for Supreme Court Justice Anthony Kennedy and also Court of Appeals Judge Harvey Wilkinson. He runs the Popular Executive Functions Substack with Bob Bauer. My colleague Diego Zambrano is Professor of Law, Associate Dean for Global Programs, and Faculty Director of the Neukom Center for the Rule of Law at Stanford Law School. Professor Zambrano's primary research and teaching interests lie in the areas of civil procedure and comparative law. A central focus of his research is private enforcement, the distinctively American phenomenon of regulating major policy areas through private litigation rather than public agencies. Professor Zambrano is authoring a book on this subject, How Americans Enforce the Law, which traces the historical roots of this regulatory approach and evaluates where private enforcement is effective and where it falls short. He also has an interest in comparative constitutional law and legal developments related to Latin America. So with that, I will sit down and we will begin our discussion. So, as you know, there have been many developments related to the domestic and international use of the military in recent days. On Saturday, many people awoke to the news that the Delta Force unit of the US Army had extracted President Maduro from Venezuela overnight. This action was only the latest of a series of military activities that the US has undertaken with respect to alleged drug smuggling from Venezuela. Additionally, the Trump administration has called up the National Guard domestically in a number of US cities. These various uses of the military and National Guard have raised a lot of constitutional and legal questions. This session will delve into those as well as addressing other possible use scenarios that could be on the horizon. Beginning last June, President Trump began to order deployment of the National Guard in a number of cities, starting with Los Angeles and then continuing with Chicago, Portland, and DC. There have been various legal battles over these uses of the National Guard, culminating in the Trump administration's loss over a question of statutory construction in the Supreme Court's emergency docket last month. While some litigation was ongoing despite that determination, Trump announced last week that he would be drawing down the National Guard in some of the most contested locations, including Los Angeles, Portland, and Chicago. It will remain, however, in DC, New Orleans, and Memphis. Trump also stated while drawing down the National Guard that we will come back, perhaps in a much different and stronger form when crime begins to soar again, only a matter of time. The Trump administration has also sparked considerable debate and concern within Congress by using military force to strike boats alleged to be carrying drugs from Venezuela to the United States. Questions have arisen about the legality of these strikes, both in terms of the domestic legal landscape and in relation to international laws of war. Additionally, on September 2nd, a second strike occurred after a boat was destroyed, killing survivors. This second strike has been criticized for violating various aspects of the laws of war and has generated various back and forth between Congress and the administration. Most recently, as all of you know, US forces took President Maduro from Caracas to Brooklyn, where he will face trial under a federal indictment. While the vice president remains in Venezuela, President Trump has said that the US will, quote, run the country until such time as we can do a safe, proper, and judicious transition. Okay, so we're gonna start out this session with the National Guard, then move on to Venezuela, then turn to some questions from online, and at 1:40, we'll turn to questions from all of you. So let's start with first the domestic use of the National Guard. And this is going to be related to this slide 10 USC section 12406. So Professor Goldsmith, can you walk us through the different possibilities for domestic use of the military and what the Trump administration chose to do when it called up the National Guard and why it chose to do that?
Sure. Thank you for having me. Thanks for coming today. So the first thing I want to emphasize is that the president has an extraordinary array of statutory authorities. We've only touched the surface with this statute and the Insurrection Act. He has an extraordinary array of statutory authorities Congress has given the president a variety of contexts to federalize the National Guard, to make state National Guard under the control of the federal government, and then to use the National Guard for various purposes. And the President Trump, we're going to go through why this statute failed, but he has many more statutes in reserve, not to mention some Article 2 power potentially that he could use to use both the National Guard and the regular military in the domestic sphere. They chose the worst possible statute as the basis to federalize the National Guard. This statute had rarely, if ever, been used. It's an early 20th century statute. And and there were two parts to the deployment. One, there was the federalization of the National Guard. This statute was at issue in Los Angeles, Portland, and Chicago. This was the statute coming from Chicago that the Supreme Court ruled on a week or two ago in ways that kind of shut down what Trump did. And they relied on, it says that the president may call into federal service members of the units of the National Guard, blah, 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 whenever, and then look at 3, when the president is unable with the regular forces to execute the laws of the United States. So that's the predicate, the main predicate that they relied on. The question in the Supreme Court on an interim order basis coming from an injunction in the trial court that had enjoined the implementation of the Guard was whether the president was in fact unable with the regular forces to execute the laws of the United States. The question in the lower courts had been factual question about inability. The Supreme Court, this gets complicated and I'm not going to get into the weeds unless you want to ask the questions about it, ruled that regular forces here meant not the regular forces of U.S. law enforcement, but meant that the U.S. military regular forces, i.e., the president under this statute can only federalize the National Guard if the regular forces, i.e., the U.S. military, is unable to execute the laws. And since the president had not shown that that was the case and had not shown that he had legal authority to even use the regular forces, that was the very odd basis. And if that's not clear, it wasn't clear in the Supreme Court opinion either. That was the rather odd basis for the court to say that the president lacked the authority to do what he was doing in Illinois, California, and Oregon. On that basis, the Trump administration decided to stop those deployments last week.
So you referenced the Supreme Court opinion, and Justice Kavanaugh in his concurrence cites to some of your work, actually. And I'm curious about if you could elaborate a little bit on what you've talked about in terms of the protective power. And you've suggested that President Trump could use the protective power or invoke the Insurrection Act if he wanted to use the military domestically in the wake of the SCOTUS decision. So I'm just curious about what the difference is, as you would describe it, between the protective power and then also using the regular forces to execute the laws of the United States.
Sure. I'm sorry, I'm going to try to make this as simplistic and clear as I can, but it's not simplistic or clear. So the protective power is, I might call it an invention of the executive branch. It has a 150-year history, and it's the idea that the president can use either the regular armed forces or a nationalized National Guard to perform protective functions in the domestic sphere. Not law enforcement, but protective functions, basically defensive functions. There's a famous opinion by former Chief Justice William Rehnquist when he was the head of the Office of Legal Counsel, famous in the OLC world, where not famous generally, where he said, he articulated this in a 3-page opinion saying, that the president has the authority to bring out the regular military to make sure that the channels of there were protests and members of the military couldn't get into the Pentagon. And Rehnquist said that even without statutory authorization, the president could bring out the military to ensure that the functions of the government can continue. This has never been blessed by the Supreme Court. It's based on two 19th century cases, one called N. Ray Nagel that really doesn't stand for the proposition that the executive branch says it stands. The protective power was actually involved in a way in the California, Illinois, and Oregon deployments. I'm not going to get into that, but it's open to the president after this decision to say, okay, if you won't allow me to federalize the National Guard under this statute, I'll just use the protective power. I'll just bring in the regular military and have them perform these defensive functions. That's what the National Guard was doing, with reporting to protect ICE from attacks and attacks on ICE buildings and blood. So the president has the option under executive branch law to bring the regular military in to perform these protective functions if he wants. I think that's a dangerous move for him, both politically and also because it's not at all clear to me that the Supreme Court is going to bless this theory that the executive branch has been relying on for a while. I'll just say briefly, maybe we can talk about it later. The hammer, the big gun that the president has after this decision is the Insurrection Act. The Insurrection Act is a series of statutes going back to the 18th century that gives the president very, very broadly worded authority to use the regular military and the National Guard, but more importantly, the regular military, not just for the protective function, but also for law enforcement. And that is the real superpower that the president has in reserve. This is a statute that is extravagantly broadly worded. The Supreme Court precedent saying that the president gets lots of deference on whether the predicates under this statute are satisfied. So this interim order 10 days ago or whenever it was, as Trump said in his Truth Social tweet, we've got other options next time there's violence. I think he quoted that. He has many, many other legal options.
So yes, I want to get into a little bit what you mentioned about the Insurrection Act, because you have a really compelling piece in the New York Times with Bob Bauer about the Insurrection Act. But just to kind of frame it a little more, the Posse Comitatus Act, which is up here, basically prohibits the military from being used for domestic law enforcement purposes. And then the Insurrection Act is a kind of exception to that. Now, your piece in the New York Times argues that Congress should reform the Insurrection Act because it gives too broad a scope of power to the president to use the military domestically. And one of your critiques is that the triggers listed in the Insurrection Act of obstructions, combinations, assemblages that make laws impractical to enforce is too vague and open to construction. And I think, in the wake of the deployment of the National Guard, some courts, including courts in California, have weighed in on whether there really was a rebellion or not that would be sufficient to trigger use of the National Guard under the other statute. And so I'm curious about your thoughts about whether there are ways for courts to at least judicially limit the triggers for the Insurrection Act, or if you think that wouldn't really fly in the Supreme Court.
Okay, so this is one of three core provisions of the Insurrection Act. There are others. And I'm not going to walk through this, but if you read this, it really is an extravagant delegation of authority to the president. And notice the end gives him all these predicates. And again, there are other provisions that give him other predicates. All these predicates for when the president considers that there's an unlawful obstruction, combination, or assemblage. When the president considers means the president gets deference, or later on, as the president considers necessary to enforce those laws or suppress rebellion. This is a much more open-ended provision than 12406, and it authorizes the president to use troops to enforce the law, and there are other provisions like this that are just as broad. I'm not saying that there are no ways that the court could construe this to try to constrain the president. There are also Supreme Court precedents going back to the 19th century that construe this language to say that the president gets significant deference, whether these triggers are satisfied. But this is a massive loaded missile for any president of the United States. Now, let me just say something that's important. every president that I know of that's considered using the Insurrection Act has shied away from it. And the DOD hates it because it's political dynamite, one used to think, to bring in the regular military into the domestic. And there's a very powerful set of norms in the Defense Department, at least there traditionally have been, against U.S. military being deployed in the domestic sphere to do law enforcement. And it turns out that those norms, a word we've heard a lot about in the last 10 years, did a lot of work in keeping presidents from invoking this. Well, President Trump is not beholden to those norms the way other presidents are. So I mean, there are ways to construe this narrowly, but it's narrower, but it's not easy. And this is a very dangerous thing.
And do you think it's because of the norms that President Trump didn't invoke the Insurrection Act in the first place instead of calling forth the National Guard under a statute that you said is not really the best justification?
This is pure speculation. I don't know. But it is a politically more serious step to take. They're clearly shying away from using it thus far, probably because of the politics. You know, governors don't like to use the federal troops in the homeland. He's only used them in democratic states for the most part. I don't know why they haven't invoked it yet. The truth is there hasn't been a precedent for the invocation. I do believe that if there were serious violence in a way that satisfied one of these broadly worded triggers, that they will invoke it. They're a much stronger legal ground, then it would be much harder for the Supreme Court to say no. The 12406 ruling last week, I can't emphasize what an anomaly that is. The Defense Department, a lot of people think just blew it and picking the wrong legal authority. It was just a legal mistake. They had better authority. So I wouldn't take solace from last week's ruling to think that they have many more legal tools. I don't know why they haven't invoked it yet. Probably because there hasn't been the need to.
Yeah, I just want to follow up on one point about the Supreme Court ruling. I'm just curious if you have thoughts about the nature of that ruling. It was unusual in a lot of different ways. You know, first of all, as has been happening more frequently, it was an order that wasn't fully argued before the court or briefed in the same way as a merits decision would be. And then also they requested additional briefing on an issue that was not raised by the parties, but by an amicus. And so I'm curious about your thoughts about that. Justice Kavanaugh kind of critiqued the majority for deciding it on that posture without additional briefing. I don't know what you.
I mean, this has been, the interim orders docket, as I call it, as everybody probably knows, has been the primary way that the Supreme Court, 10 years now, really, has been reviewing the executive branch initiatives. These are interim order rulings. This is the way the court has proceeded this year. It's the way the court proceeded in the Biden administration and the first Trump administration. It wasn't terribly unusual in terms of as interim orders go. It was a little unusual that they ordered an extra round of briefing, but that wasn't ordinary completely. What was interesting was that the justices who were usually complaining vociferously about, they decided a lot of new legal issues in this little paragraph interim order. The justices who were usually complaining vociferously about using interim orders with deficient process to make new law in important cases, Justice Kagan, Justice Sotomayor, Justice Jackson quietly joined the majority opinion and didn't make that complaint, which I think is very revealing about process objections to interim orders. I don't think it was that much out of the ordinary compared to a lot of the other very important taking place this year. They've all been very important. And this interim order had the effect of shutting down the deployment in those three states.
I think you hit my question on the process.
So let's change topic a little bit and turn to the situation in Venezuela. And you're from Venezuela and have thoughts on the situation. So can you maybe give us?
Yeah, so I'm from Venezuela, born and bred. My family's there, parents, my brother's there, and my extended family. So I want to wear two hats for a moment. I have a kind of Venezuelan hat that I want to put on and give you some personal reflections. And then I'll wear my US law professor hat on and talk about the legality of this. I have some questions for Jack on. For most Venezuelans, overwhelmingly, this was a day of joy, happiness. That may be a surprise to many of you, but Venezuela has been living under this brutal dictatorship for 26 years. This was a guy who ordered the extrajudicial assassination of tens of thousands of people, of students protesting in the streets, a guy who tortured tens of thousands of people, uncontrovertible. We have reports from the UN showing the evidence of all of this. This is someone who eviscerated the country. The country collapsed even more than Syria did during a civil war. 8 million people left the country, the largest humanitarian catastrophe in the Western Hemisphere in modern times. And so this was a day of profound relief for Venezuelans. And that's why you've seen probably lots of celebration, if not domestically, because the repressive apparatus of the state is ready to continue to repress people. So I just wanted to start with that. Now, of course, there's a lot of uncertainty now. We don't know whether there's going to be a successful transition or not. You might have seen in the news that the Trump administration is negotiating with the acting president, Delcy Rodriguez. And the positive, optimistic path is that the regime agrees to a transition and we get a new election by the end of the year and the opposition takes control. It's going to be difficult. It may not happen, but everyone has an immense amount of hope that that is what is going to happen. And we'll have to wait and see over the next few months and steps. Now, let me talk a little bit about the US law professor side. I have some mixed views about the legality of this, and I want to talk to Jack about it. It does seem to me that the case of the US invasion of Panama in 1989 is precisely, almost exactly analogous to the situation here. Like in Venezuela, the US indicted acting dictator General Noriega of Panama. Like in Venezuela, the president, H.W. Bush then, Trump now, ordered an invasion, or let's say a military operation to seize the acting dictator, Noriega and Maduro. Neither President Bush nor Trump sought congressional approval. So those are exactly analogous here. And in fact, the deployment in Panama was much larger and for an extended period of time, over a month. Here it was only a few hours. When the US invaded Panama, Congress was not in session. But when Congress returned to session in January, the House of Representatives adopted kind of a resolution praising the military operation, which seems to me like congressional acquiescence. Of course, the Senate did not, just the House, but congressional acquiescence with this kind of presidential action. And so let's just start there, Jack. Why or why not? And I know you've written about this and you have a great post on it. Are there any differences between this and Panama?
There are potential legal differences. The Panama matter was easier to justify because there had been a Marine killed, U.S. citizens attacked. The invasion, and Noriega, or the legislature, I forget what it's called, had declared that the United States and Panama were in a state of war. So if I'm writing an OLC opinion, that makes the opinion even easier to write because there's a self-defense element going back to the states can use force in those circumstances, especially once a war has been declared against them. Those are distinctions that make the Panama matter easier, but I think again, I want to make a distinction between profuse executive branch precedents on the president's war powers and what the law of war powers actually is, which is a harder question. I still think it's pretty easy to justify under invasion, pretty easy to justify under domestic law, not in domestic law, under these Justice Department opinions, which basically have justified the president's offensive use of force practically whenever he wants.
Yeah, so we're only talking about domestic law. I'll touch on international law in a moment. But can you say more about the law enforcement side of this?
Yes.
Which seems to me the main justification the Bill Barr's memo touched on.
So former Attorney General Barr was once the head of the Office of Legal Counsel, and in 1989, he wrote an opinion that basically said that FBI had the authority to arrest persons who violated U.S. law abroad. So that, in other words, the United States could make extraterritorial arrests in other countries, even if it violated sovereignty, even if it violated international law. I think that opinion was the primary basis for the invasion over the weekend. During the press conference, you heard words to the effect of this was an apprehension operation. This was a law enforcement operation supported by the military. They were tying into this Barr opinion that the U.S. law enforcement was allowed to arrest abroad. That's the first half of the justification. Second half of the justification, and I'm simply just talking within the four corners of executive branch understanding, is that the kinetic force and the boots on the ground, the military boots on the ground, were meant to defend the persons engaged in the law enforcement. Now, this may seem a little perverse that you can claim the power to arrest someone in another country and then along the way claim the power to kill 40 people and blow things up to defend the people who are going in for arrest. But that's essentially what I think the legal justification was. And you can stitch together these opinions to work that. I don't think it would have been a terribly difficult opinion.
And again, under domestic law, this memo does not seem to differentiate on whether this is a head of state or not, or a parent head of state in any case.
Exactly. It doesn't distinguish at all. And Maduro hasn't been recognized. I think he's not been recognized for a while by the United States. So that's the president's call for U.S. law purposes completely. So that wouldn't have mattered.
And what about all the different kinds of bombings presidents have engaged in? Libya for Obama, Kosovo for Clinton, who admitted this violated international law, but was the right thing to do. Do those support presidential unilateral, again, under domestic law?
I mean, there are so many instances and so many contexts, we could spend 15 minutes going through them, of presidents using unilateral force under a variety of justifications. I mean, it's not just those. There's Libya, there's Kosovo, there is all the Iraq.
Somalia in the early 90s.
Right? There are actually dozens going back to the 80s. And they all are variations on a theme of either this very broad conception of self-defense or self-defense of allies, or that the U.S. national interest, broadly construed, permits it. There's also very robust practice in the late 19th and early 20th century of the United States invading South and Central American countries all the time to achieve various policy and commercial aims. I want to say one thing. The fact that there are a lot of precedents doesn't mean it's lawful necessarily, but it might, this is a complicated conversation, it might mean that it's lawful because separation of powers tend to be informed by longstanding executive branch practices. Congress hasn't done a great job of standing up to the president. Whether it's lawful in some sense outside of these executive branch opinions is kind of a very hard question to answer. The Supreme Court has never weighed in on this. But the executive branch is an easy time.
And I want to touch on two more things that you said. I feel like that's loud. Two more things you said in your post. One is that the executive might recognize that it needs congressional authorization if there's a prolonged occupation. And we do have the War Powers Resolution, the 1690 days. The 1690 days.
Yeah, so there are two so these extravagant or promiscuous Justice Department legal opinions. That's why promiscuous uses of executive power. The one limitation that the Office of Legal Counsel has recognized as a possible limitation is that if the president sends troops into boots on the ground in a prolonged way, lots of soldiers, and the soldiers are threatened, in that situation, OLC has said maybe Congress has to authorize that. That's one clear exception that they've recognized. That doesn't seem to be implicated here yet, even though President said we were on the ground. That won't be implicated. The War Powers Resolution 1973 statute that was Congress's effort to put some constraints on presidential war powers after Vietnam. We can get into the weeds if you want. It's proven to be Swiss cheese and it posed no great obstacle to presidential unilateral use of force. First of all, it gives the president 90-day free ride to engage in hostilities before the statute even gets triggered. And then even after that, presidents have options to circumvent the statute, so that should not be a serious issue.
Now let me move on to international law, which again, the microphone. Let me move on to international law. So we have an international prohibition on the use of force, except in self-defense. Clearly, that's not triggered here. Pretty easy analysis on the legality in their international law.
Yes, I agree. It's pretty clearly a violation of the U.S. Charter. Not the first time the United States has done it. I will say this, I've been waiting the last 3 days. Hear you. I think that's me. I've been waiting the last 3 days, and I have a modest prediction that in the next week, Trump administration will claim that it had the consent of Venezuela. Who did it have the consent of? Someone in the Venezuelan government that it recognized as the lawful representative of Venezuela. And consent to use force here would be a way to make the problem go away. Now, wouldn't it all be surprised if that pops up on the radar screen when someone figures out that that would have been a useful argument to make if they can drum it up. But other than that, I think it's clearly robust.
But yeah, that's exactly what I wanted to ask you. Consent. It's not just consent potentially from someone within the regime, but also the actually elected president, the legitimate elected president, Gonzalez, who's abroad right now. There's clearly a request there that the U.S. intervene. And we, from every survey we have, vast majority of the population of Venezuela supported this intervention. So what about that?
So they would have to say, the only trick with that is that the government, U.S. government, would have to say that we recognize, and this they've shied away from doing for reasons maybe you can explain. I don't know. They would have to recognize her as the head of the government that could make this. They haven't done that yet, and maybe they could do that retroactively. Maybe they did it secretly and haven't told us yet. But they would have to do something.
And there's a political calculation there that we can talk about. I do want to ask you one more thing on the potentially domestic international law side, which is the head of state question again. It will come up in litigation, Maduro in New York. So Noriega claimed head of state immunity. The United States said, we don't recognize him. You expect this will come up, and the court will again, like in the Noriega case, say, if the U.S. doesn't recognize him as the head of state, he does not get head of state immunity. Correct. I think that would be the clear result. And if I'm right on the facts, and I think you said this is true, that he hasn't been recognized head of state by the United States for quite a while, then the argument could be very useful.
And it ask you a little bit about the legal justifications for that. Also, Ruth Marcus has said that the boat strikes are dramatically different than other uses of military force before because they're targeting civilians. Do you think that that's the case? And what do you think are the legal and political justifications for the strikes generally?
It's not the first time the United States has used force against civilians. I mean, most of the rest of the world thought that most of American use of force against terrorists off the hot battlefield was a use of force against civilians. We didn't think that, but most of the rest of the world. That was a different context. This is a much harder context. We've also, again, in the 19th century, military use of force against private actors, including smugglers. That said, it is a step beyond what has recently been justified by the Justice Department. I can imagine national interest argument saying that it seems to me that the entire threat posed by these speedboats, I'm not an expert on this, is either false or pretextual. It seems some of the things they've said about the boats and the threats they seem ludicrous to me, but it's a step beyond basically to go after criminals using force, and it's in modern times unprecedented, and pretty clearly, again, might be able to have a justification under domestic law. It pretty clearly violates international law. We're not in what's called an armed conflict with these drug runners, if that's what they are. So again, I think you could jimmy up a domestic law justification. You could find some precedent, but it pretty clearly violates international law. But the administration doesn't serve.
So just pulling back from these two separate scenarios and the domestic versus international use of the National Guard or military, do you think there's anything that can be said more generally about this administration's approach to the use of the military? And also, given your experience working in the executive branch, do you have thoughts about kind of the role of the Office of Legal Counsel here or other lawyers? And is it different than in earlier administration?
As best I can tell, it is different. So the Trump administration, like no administration in American history, this second Trump has imposed a kind of vertical loyalty test and litmus test not to deviate from legal interpretation. It's literally in a directive from either the Attorney General or the White House, I can't remember. And it's been enforced through firings if anybody deviates. So this is not an administration that's getting a lot of independent legal advice. It happens in normal administrations. It's not always listened to, but it does happen in normal administration. That's clearly gone. They fired the top JAGs in the first week. I imagine that this is extremely traumatic. We just know this. The Defense Department actually, this may be surprising, they actually can care about law compliance. They care, at least traditionally. I was there. I think the vast majority of the DoD culture, I think HEGSAP is actually trying to change this, but I think he's changed it at the top. I imagine this, and I know, because I've spoken to people, it's a massively wrenching experience for the DoD. I don't know the details of how these things are happening or what's going on. But these strikes that are on the edges, if not really violative of international law and that are relying on novel domestic law theories. Again, it's not the first time war powers have been stretched, but they're really being stretched now. Sure is causing great difficulty. The Office of Legal Counsel, where I used to work, was for the first 9 months basically cut out. They're being relied on now. My understanding is that they rely on the Office of Legal Counsel and agree with the Office of Legal Counsel when the Office of Legal Counsel want to hear, and otherwise don't. But OLC is back writing opinions, but there's no evidence of any independent. And you may be skeptical that there's ever such a check, but that skepticism is unwarranted. Not saying that Justice Department lawyers act like independent courts, but they typically do not act like criminal defense.
Well, thank you so much for this. I want to turn to questions. Well, first, I consider a couple of questions from our alumni who are in force online. We've had way too many questions to be able to answer here, which we are very grateful for, but we'll start with a few, but then also you may see that there are microphones on either side. Please, if you have questions here, please start lining up because we'll turn to your questions in around 1:40 or so. So actually the first question I'll address from alumni actually relates to this question about military adherence to the law. And the question is that the military swears an oath to defend the Constitution and has an obligation to reject illegal orders. But what is that supposed to look like? How far down the rigs would it go? And what does it look like in practice?
In theory, it happens at every level. You're under a command to comply with lawful orders, and you're under a command to disobey unlawful. Simplifying a little bit, but that's basically it. How it works in disobeying unlawful orders is a little bit fluid and contextual, but it involves given a clearly unlawful order, Again, it depends on the context, the level of decision, depends on a lot of things. But basically, you're supposed to question the basis for the legal. If you think it's clearly unlawful, you're supposed to question the basis for the legal analysis. Lawyers are consulted. And if you think it's unlawful, you basically have to resign. But you run the risk though of doing that. It's just built into the system of being court-martialed. It's a lawful order. So it's a very tricky position that the subordinate is in dealing with it. I mean, these things tend not to come up a lot. Mens rea, if there's ever a trial, is usually hard to prove, but you do have these kind of conflicting obligations or intention obligations to comply with an order, not to comply with an unlawful order, not clear whether the order is lawful or unlawful, especially if you're not a lawyer. A tough situation.
Thank you. So another question that we got from the alumni is to please comment on the implications of the Trump actions in Venezuela, and the person is concerned about, what might happen with Greenland or Canada as a result. Do we think that this is a precedent for further actions abroad or not?
I obviously have no idea. He's been talking about invading Colombia the other day. Venezuela's back on the map. I would, even given everything that Trump says and is capable of doing, would be surprised if he invaded Greenland. There are lots of, if he wants to claim sovereignty over Greenland and capture, there are lots of legal and political. And as the people in Greenland have been pointing out, you can do anything you want here anyway. Why do you want to propagate us? I can't assess the likelihood of that. I have no idea.
Thank you. Yeah. So another question has to do with this issue of the regular forces and going back to the National Guard here and the concern about the regular forces. So the person's concerned that the Supreme Court's adoption of the idea that the regular forces means the regular military, and so that the regular military has to be deployed before the National Guard can be used, might have a perverse incentive of encouraging presidents to bypass the National Guard altogether and instead rely directly on active duty troops for domestic enforcement. And is there a concern about that? And also, how plausible do you think that there's another part of the question that really is about whether that is the meaning of the statute?
I'll answer the second question first. This is a very strange statute with a very strange history and a very strange part of U.S. code. Never been considered by the Supreme Court. It's rarely been invoked, and there's not a lot of settled understanding about what it means. The Supreme Court interpreted it for the first time in 2 sentences in an interim order. I don't have a strong view. Let me answer the first question. That answers the second. It doesn't really make sense to me that Congress would want to ensure that the regular military couldn't enforce a law enforcement function before calling out the National Guard, because I can imagine very few circumstances in which the regular military wouldn't have been able to enforce the law in which you needed the National Guard. So it just, as a kind of logical matter, it doesn't make a whole lot of sense. There are good arguments that were made in the briefs that this should be interpreted to be regular forces. But the first point is the important first point he made. The Supreme Court's interim order incentivized, it basically, part of the order we didn't talk about said that the president could not, I'm not going to get into the weeds on it, it's too complicated, but that the president could not invoke this statute because he had not shown that there was, this gets back to the posse comitatus statute, that there was some authorization to use the regular military in the domestic sphere. The Supreme Court said that was a prerequisite for using the statute, to which the Trump administration can turn around and say, okay, if you want us to have an authorization to use the regular military in the domestic sphere, we'll invoke this broad, powerful Insurrection Act. It does, I wouldn't say incentivize that, but as I said in something I wrote, you can easily imagine the Trump administration invoking the Insurrection Act and saying, the Supreme Court made us do it.
Thank you so much. So do you have any further questions or should we open? I see you're here. Would you like to?
I'm sorry, I didn't hear the question. Could you ask again? I mean, I base this on what Hegseth has said and what DOD has done. Hegseth criticized, coming into office, and since he's been in office, criticized what he viewed as the Defense Department's overly fastidious adherence to the laws of war. They become too legalized, feminized. And first thing he did was fire the JAGs. He's since been pushing very aggressive law of war defying actions. He, in many of his public pronouncements, very disrespectful. This culture of wanting to comply with law and the laws of war is something that is real and grew up in DOD after Vietnam, after My and others, and was part of a decades-long effort that most people in the Pentagon thought served forces well, regular armed forces discipline and the like. Hegseth just disagrees with that, and so that's all I know that he's been doing. Some evidence based on what DOD has been doing that he's successful. I do not know how deeply into the culture goes. I know, talking to people, that there are people at the very top of the administration in DOD who are worried about it, who don't like it, but it's a very awkward and difficult situation to be in. Question whether to stay or resign is always complicated when involving personal factors, involving the question whether if I leave, if does the person replace me going to be worse, whether we can stay and try to keep things as they should be. But anyway, that's basically the evidence.
You want to go next? Thank you very much. I wanted to ask, I understand that it sounds very good. Statement. But it's one thing to free the population and it's to secure their safety. This is a process. This is not just one time thing that you're doing. I'm trying to understand what's the responsibility of the this process and how was it considered? Because the history.
I mean, do you want to?
Yeah, let me start by saying again.
Oh, here.
He's asking about the ability of the U.S. to shepherd the transition now in a way that works and the dangers of it not working. But you made a point that history shows it doesn't work, but it's not true in Latin America. The most analogous case is Panama. Panama worked out amazingly well. Panama transitioned to democracy, and it is a wealthy country now with a stable democracy. Now, are there reasons why Panama is different? Yes, of course. Venezuela is larger, much larger than Panama. And the military is not committed to a transition right now. And so, yes, there is a lot of uncertainty. There's a recent paper analyzing every US intervention in Latin America, mixed, but more positive than negative, actually. Latin America is very different than the Middle East. Latin America is very different even than Eastern Europe. And so I think any analogy to the Middle East are wrong. I would say an easy heuristic is that countries revert to the mean. They tend to return to the institutions that they had before. And when you have no institutions, as Afghanistan did, you have a mess with the Taliban. Venezuela had a stable democracy for 40 years, the strongest democracy in Latin America. We should expect it to reverse to the mean if the regime allows a transition. That would be my point. Now, does the US have an obligation? I think, hope so. I hope they see themselves as obliged to shepherding a full transition to democracy. I don't take seriously any claims about owning the oil or anything like that. That's not what Marco Rubio is saying, although that's what Trump says. It's hard to take any of that seriously. So I don't know if that addresses your question.
So thank you for the presentation. I guess I had a question about, it seems like you outlined a spectrum of involvement from apprehension operations to full-on occupation, each of which requires different levels of authorization of contract. And from, I guess, what the president's been saying and from what other cabinet officials have been saying, it sounds like there's a spectrum of US involvement that could unfurl, either, I guess, coordinating with Vice President Rodriguez or a full-on military operation where the US runs the country. I'm curious whether or not, I guess, such foreign interference in Venezuela on part of the US, whether or not there's a similar gradient of congressional approval that needs to occur, or whether or not the president and, I guess, the executive branch can freely deal without too much congressional oversight.
Sorry, with regard to what spectrum?
Oh, sorry. Yeah, so I guess the first spectrum that you outlined was the spectrum of military involvement from apprehension using military forces to full military occupation. And it sounds like there's a parallel spectrum between, coordinating with the current Venezuelan administration to America running the country, as the president has been saying.
So the more the situation, becoming a large military occupying force on the ground, as in Iraq. Or the argument that authorization arises. Remember, there was authorization in Iraq. So the legal argument becomes harder for people. And it gets a lot more complicated because then they're an occupying all sorts of complicated rules. It also becomes a question. So it gets legally and politically, and probably gets politically much harder as there's a larger presence on the ground. When I first heard President Trump say we're think pretty clearly, then since he can not that sounded like to me, he said that we're going to have a big press during the running. I thought he was talking about station. It doesn't seem to be what they're talking about. Right now, the dominant theme seems to be there to achieve the end. That is professional involvement under these things. Congress could get involved if it has no involvement.
Thank you. You spoke about the use of the military for law enforcement capabilities abroad, and I was wondering if you could talk a little bit about, the judicial process following it. The Supreme Court in the Verdugo's case said that the Fourth Amendment doesn't apply for foreign nationals abroad unless they are voluntarily attached to the United States. And I was wondering, for the President Maduro's case, given that the charges are conspiracy and in specific relations to violations of U.S. national law, are those sufficient to raise this voluntary attachment standard? And if not, are there mechanisms that we can, operationalize what voluntary attachment?
I don't believe so. I think this case is going to be governed by the Alvarez and Shen case, where there was specific. I don't believe that there's going to be any law. I'm not an expert, but just based on what I know, don't believe there are going to be any laws. Fourth one, life or death. You will have states, Supreme Court. That argument didn't work for Noriega. The same reason I think it won't here. For all the reasons that the other arguments didn't work for Noriega, head of state immunity, statutes weren't prisoner, not. There were a few other arguments. I think it's basically going to be largely head of state immunity. I mean, largely a retrial of Noriega. That case didn't go to the Supreme Court. Law has moved forward, but I'm not quite sure about that.
Yeah, thank you. I'm curious about the relationship between the UN Charter and the Supremacy Clause. If we ratified the UN Charter in 1945, I'm curious, is it a treaty for Supremacy Clause purposes? If it's not, I'm curious why not. If it is, I'm curious how it could be sort of enforced as not international law, but as domestic American law and kind of get caught up in the president's take care powers, et cetera.
Yeah, that's a great question. Not completely settled, but I'm very skeptical that the Supreme Court. The Supreme Court has already said that aspects of Medellin, where court didn't say this, but it strongly implied, and it's a different context, strongly implied that one aspect of the charter wasn't on that self-executing, strongly implied that the charter wasn't self-executing. The charter did not apply it. I don't believe that's what the Bill Barr opinion knows. This is not a settled issue, but I do not believe. Also, there are no individual rights under the charter, so even if the charter applies, no way for an individual to take advantage of it. This was basically what the reasoning was. That reasoning has been strengthened by the Medellin. So I don't anticipate that the charter. Just to repeat, that argument was made in Noriega and rejected, and since then the court has ruled. You agree with that?
Well, I read your post where you talked about the OLC memorandum, and you addressed this argument. The OLC memorandum does talk about it, and it does conclude that the president may authorize arrests even if they violate international law, and that the charter does not constrain domestic executive authority.
But even since then, that was the executive branch, right? We've had the 11th Circuit saying that, and we've got the Supreme Court decision in an analogous context. Don't think that argument.
That's such a great question. It's the one I was going to ask. But separately from the question of whether or not I mean, we talked about the juxtaposition between the analysis of this intervention in Venezuela under U.S. law, constitutional law, and then under international law. And, you know, probably under international law, it's okay. Domestic law, it's okay. Under international law, it's quite clearly impermissible. Right. So quite apart from the self-executing question, right, that you raised, what about the take care obligation, right? I mean, international law, whether or not it's self-executing, international law is part of the law of the United States. And is the Bill Barr 1989 opinion, when I was in the government back in the legal advisor's office, we kind of used to say the president has the right to violate international law kind of whenever he feels like it. But I'm not sure if that's your reading of what the OLC teachings stand for. And then just a comment, Diego, I don't think we have any invitation from anybody who qualifies as a head of state in Venezuela for this intervention, right? So Gonzalez, to the extent that I've seen any evidence, the record has actually stated he didn't want a U.S. military intervention. I'm trying to look at my phone and figure out whether that's really true. Machado is not the head of state. The last statement that the State Department made about this is that it recognized the legislature as the last legitimate institution. So I think and I don't know that you can do retroactive consent. I don't know if somebody can subsequently attain status of a head of state. So that's a comment. I'm very, very doubtful about the consent claim under these circumstances.
And you might be skeptical too, because I'm not sure that the US argued that during the Panama case, even though there was also an elected, democratically elected president that was in favor. Right, right. Yeah.
So let me just explain what a self-executing and self-executing and a non-self-executing treaty is for those of you who don't know. So the United States enters into international agreements, treaties, and other agreements. And those agreements, if they're legal agreements, are binding under international law. But there's a separate question whether they have status in the domestic realm. And even that phrase is a little ambiguous. And the Supreme Court has said from the 19th century that only a subset of treaties are enforceable domestically. These are so-called self-executing treaties. Even that definition of what's a self-executing treaty is unclear, but it basically means a treaty that by its terms purports to be automatically enforceable. Your question is the president under the take care clause, which says the president has a duty to take care to faithfully execute the law, does that duty apply to treaties? Treaties are law. And the question is, if the UN Charter is a non-self-executing treaty and does not have domestic effect, whether it's binding on the president. I think this question, it's never, the bar opinion says not binding on the president because it's non-self-executing. Academics disagree about this. There's not a lot of firm case law in the lower courts, but I believe given the historical practice of presidents often violating the charter and the Medellin decision, there's a lot of language in Robert's opinion, especially some footnote 7 or something like that, where he defines non-self-executing in a way that strongly suggests it won't be binding on the president. And I think that view will prevail in court. This is exactly what I meant when I said that the arguments that the treaty is not going to be available to Maduro are much stronger now than they were for Noriega, precisely because of the language in Medellin. Do you agree with that? I agree. I agree. Right. I agree with you. It drifts towards in the direction of saying it's not domestic law and not binding. It says not binding at some point. And that opinion was written by Chief Justice Roberts. And I think that opinion will prevail.
I'll just say briefly, seems to me that the strength of the prohibition on the international court constantly being derogated, a weak norm. The norm against annexing territory is a strong norm. Russia is challenging. But this is a norm that has been violated 40 times in the last couple of decades. And we're going to highlight the one case where it's actually deposing a brutal dictator to restore a democracy that the population supports and the leaders outside the country that were elected also support. I think international law should evolve. I think it needs to embrace some notion of popular sovereignty, that if a country's population really favors the intervention, there's some room for that. That is not the case whenever Russia and China intervene abroad. Ukraine did not want that intervention. The people of Ukraine do not. The people of Taiwan do not. This is not comparable at all. It does not excuse whatever China and Russia want to do now. This is a situation uniquely where the country wants it. Look at the survey data showing this, where the elected officials, and Alan can talk about this, won it. Legitimately elected officials, because there was an election in 2024, and Edmundo Gonzalez won with 67% of the vote. So I don't understand, and I don't subscribe to an international law that safeguards such a dictatorship. A weak norm.
Let you have the last word.